Case number 19-7167, Military Order of the Purple Heart Service Foundation, Inc., a Florida corporation, and MOPHSF Holdings, LLC, a Florida limited liability company, versus Military Order of the Purple Heart of the United States of America, Inc., a District of Columbia Corporation, appellant. Mr. Herrick for the appellant, Mr. Stern for the appellate.
Mr. Herrick, can we hear you?
I hope so, Your Honor.
I hear you fine. Okay, before you start, can we just ask Mr. Sturm to unmute Mr. Sturm and make sure we can hear him so we don't get caught midstream again?
Your Honor, can you hear me?
Hear you fine. Okay, very good. Mr. Herrick.
Thank you, Your Honor, and good morning. My name is Stephen Herrick. I represent the Military Order of the Purple Heart of the United States of America in this appeal. I would like to start by addressing the case in which the order is the plaintiff. That's case number 996, which alleges the Foundation's breach of the 2016 agreement between the order and the Foundation. Section 3.3 of that agreement required the Foundation to fund the reasonable budget submitted to it by the order. And the Foundation, in fact, agreed to fund a $6.4 million budget submitted to it by the order for fiscal year 2019. The Foundation has argued that it never entered into a binding commitment to fund the order at that level, but it is our view that this argument should receive no consideration from this court, as it is belied by the language of the approval letter by Foundation Chair Mr. Woolley, which stated, quote, the restricted grant for the next fiscal year is as follows: 2018-2019, $6,400,000. Now, the use of the term restricted in Mr. Woolley's email is not explained, but apparently it is a reference to grant documents issued by the Foundation in prior years, which stated that the Foundation had the right not to fund the grant in whole or in part based upon its financial condition during the term of the grant. However, unlike those prior years, the Foundation did not issue any grant document for fiscal year 2019, let alone one conditioning its funding obligation on its ability to pay. And the Foundation CEO, Mr. Ruckman, testified at trial that the Foundation sought no such condition to its approval of the order's FY 2019 budget because it believed that the order would not agree to it. And in this regard, Mr. Ruckman's assessment is absolutely correct. Given the Foundation...
You're deep in the weeds of extrinsic evidence, right? And the district court considered extrinsic evidence and made findings of fact against you on this point. So
understood, Your Honor.
you have a...
Okay, so moving on to the legal point here. Okay, Section 5.2 of the 2016 agreement provides that in the event the Service Foundation does not found the order, the assets or control of the new entity will be transferred to the order. And that new entity is Holdings, the holder of the word-marked Purple Heart. The district court refused to read the does not fund language of Section 5.2 of the 2016 agreement in the context of the will fund the reasonable budget language of Section 3, finding that the $2 million shortfall did not constitute a breach of the 2016 agreement. In doing so, the district court manifestly disregarded primary rules of contract interpretation. A court must interpret the language of a contract as a whole, giving a reasonable, lawful, and effective meaning to all its terms, and ascertain the meaning in light of all the circumstances surrounding the parties at the time the contract was made. As a corollary to this rule, contract language should not be interpreted to render a contract promise illusory or meaningless. In ruling that the Service Foundation's $2 million shortfall in funding the order's 2019 fiscal year budget, that this did not violate the language of Section 5.2, the district court essentially adopted the position of the Foundation that even if it gave the order only $1 in fiscal year 2019, this would not have violated the does not fund language of Section 5.2. And it is respectfully submitted to the court that such an interpretation manifestly renders the Foundation's unconditional promise in Section 3.3 to fund the reasonable budget submitted to it by the order illusory and meaningless. Moreover, the court's interpretation of the 2016 agreement fails to interpret that agreement in light of all the circumstances surrounding the parties at the time the contract was made. Specifically, the pattern and practice of the parties was that the order would incur expenses, including payroll for its veteran services officers, which would then be covered by the foundation's payment after the fact. By reducing those payments from an average of more than $500,000 for the first 7 years of fiscal 2019 to $25,000 per month, the foundation assured not only that the order would be in immediate default of its obligations, a fact conceded by CEO Ruckman at the trial, but also that the order would not in good faith be able to incur the future expenses necessary to its continued operation, thereby sabotaging the order's long-standing mission of helping thousands of veterans with their claims to the VA and operating a suicide prevention hotline. The equities of the situation also bear consideration. The reason the foundation could not fund the order's budget that it had unconditionally approved is that it had been hemorrhaging money, millions of dollars over the course of more than a decade, due to its outmoded funding model and its payment of outrageous fees to professional fundraisers, earning it an F rating from one rating service. This court should give no consideration to the appellee's reliance on the prioritization of funding set forth in sections 3.1 to 3.3 of the 2016 agreement. No evidence whatsoever was presented by the foundation at the trial to show that its failure to fully fund the order's FY 2019 budget was due to the funding requirements of the foundation's own reasonable and necessary operations.
Is that your burden, or is that their burden?
Well, I believe that it's their burden, Your Honor.
Why is that?
Because it's in the nature of an affirmative defense. They are relying on a provision that says we don't have to fund you if we can't afford, because you are the third order prioritization.
This is on your claim for breach, though.
This is on our claim of their breach of the 2016 agreement. And
With respect to this claim, you're the plaintiff.
We are the plaintiff. Okay? I am anticipating what I believe to be an affirmative defense on the part of the foundation that the order was the third order of priority with respect to funding, and therefore did not have to be funded if, after funding the reasonable and necessary expenses of the foundation and holdings, that there was not enough money to fund the approved budget of $6.4 million of the order. That argument was raised at the trial, and I believe in anticipation that it might be raised again before this court. Is our position that there is no proof in the record, and that in fact the foundation and holdings did not even make the argument that the reason that they did not fund the full budget of the order for fiscal year 2019 is because of foundations and holdings' own expenses.
Mr. Herrick, I know you don't agree with me on this point, but assume I think it was your burden. Can you still win?
Our burden to show that the reason
on the question of whether or not there was breach when the foundation did not pay the $6.5 million that the order was expecting.
I see.
And what the foundation says is, well, we went in the order of priority, we paid the foundation expenses, then we paid the holding expenses, and then we paid what was left to the third order of priority, to the order. And they say, therefore, it wasn't breach. We did what we were supposed to do. And you said, no, you say, no, you did breach. And if it was your burden to show that they didn't follow the order of priority, or that they did follow the order of priority, but they somehow wasted money on priority 1 or priority 2, if that was your burden to show, is there any way that you can still win on this question?
Yes, Your Honor.
The breach of that contract.
Yes, no, because there's no proof in the record, and I don't believe that the appellees even invoked that provision in saying that that's the reason why they didn't pay the full budget of the order. There's no proof in the record as to how much money was spent on the foundation's expenses for that fiscal year.
But again, Mr. Herrick, you keep saying there's no proof in the record, and I'm saying assume I think it was your burden to put proof in the record. What do I do then?
Well, I think, Your Honor, that the record has no evidence of expenses or on behalf of the foundation or the order, and so that is not a reasonable explanation for why the foundation did not fund the reasonable and fully fund the reasonable order budget of the order that it had approved. And I think it is, these are their own expenses. We don't have access to those expenses. And so I believe that it is fair to at least shift the burden once we show that there is no proof in the record to establish that the reason that the order's budget wasn't fully funded was the expenses of the foundation and the orders. I think it is reasonable to shift the burden to the FLEs to explain why that was the case, and that has not happened here. And I think the fact of the matter is that the reason that this budget was not fully funded was because of the mismanagement of the foundation with respect to its own fundraising efforts. And at bottom, the legal issue here is that the fair and reasonable interpretation of the 2016 agreement must be that the does not fund language of Section 5.2 be read in harmony with the reasonable budget language of Section 3.3. And in doing so, it compels the conclusion that the foundation's unilateral reduction of the payments of the order constitutes a breach of the 2016 agreement, and that these district court's contrary conclusions be reversed.
That's certainly one plausible way to read the contract, which is that the word fund in 5.2 is a shorthand reference back to fund the reasonable budget in 3.3. But it's not necessarily the only possible reading. 5.2 just says fund. Maybe that means substantially fund, and on these facts, it wasn't $1, it was millions of dollars. So why isn't that enough, at least to create enough ambiguity for the district court to resolve that question against you on the facts?
Well, I think the problem here is that under Section 3.3, does not fund is rendered meaningless if you say that any time that the foundation can come up with an excuse not to fully fund the order, in the context of the consequences of that decision, which were that the order basically went out of the business of servicing veterans because it had acquired the expenses and then was not reimbursed for them, as had been the case over the prior years by the foundation. What is the point of Section 3.3 then? I mean, it's rendered meaningless. The order has no remedy if the foundation unilaterally cuts its budget by 95% a month after the expenses have already been incurred.
Well, maybe you have whatever remedy flows from a breach of 3.3. If you think of 3.3 and 5.2 separately, maybe there's a breach of 3.3, but what you don't get is the kind of nuclear remedy of 5.2, which is that you get to take over holdings.
Well, I think the problem respectfully, Judge Katsas, with that analogy or that analysis is that the other remedy is monetary damages. And it's clear from the financial situation of the foundation that they don't have the wherewithal to provide monetary damages. And that's why, the order did not agree to the restriction, was not even presented with a restriction. Which
may not leave you with any meaningful remedy if it turns out that they have no money, but that's a little bit different from saying that just on the face of the contract, 3.3 is rendered into surplusage.
Well, I think that you have to consider all of the facts that existed at the time that this promise was made. And that includes the foundation's dire, financial situation, which they themselves analyzed before agreeing to provide the order with $6.4 million for fiscal year 2019. And the contract has to be interpreted as a whole, given reasonable, lawful, and effective meaning to all its terms and conditions in light of all the circumstances surrounding the parties at the time the contract was made. And those circumstances were that the foundation was in financial difficulty. And that was one of the things that was considered by the parties when the foundation agreed to fund $6.4 million without restriction. Didn't even offer a restriction to the order because, as Chairman Ruckman testified, or CEO Ruckman testified at the trial, they knew we wouldn't agree to it. And it would have been foolhardy for the order to agree to that under the circumstances of the situation. And so giving consideration to all of the circumstances, which is what is required, okay, under these circumstances, Section 3.3 has basically been rendered nugatory. There's no remedy, okay, and the contract remedy was specifically to turn over if they didn't comply with its funding, with the funding requirement. The remedy was to turn over the assets.
Understood. You want to take a minute or two on the claims against you?
Sure. The issue with respect to the claims by the Foundation of Holdings against the order is that the order violated Section 6.1 of the 2016 agreement, which provided that in the event the order seeks to disenfranchise or takes other adverse action against the Foundation, the 2016 agreement would be considered null and void after notice secured by the Foundation. And the district court found that the fundraising efforts by the order undertaken in an effort to protect itself from the Foundation's free fall constituted an adverse action in violation of Section 6.1. And in this regard, the district court relied on a dictionary definition of the word adverse. And in doing so, it not only ignored the complete verbiage of the relevant phrase of 6.1, which is, quote, other adverse action, unquote, but it also parsed that phrase from the specific adverse action identified earlier in the same sentence, which is, quote, seeks to disenfranchise, unquote. It is the order's position that when properly relating takes other adverse action against the Service Foundation back to the phrase seeks to disenfranchise, it becomes obvious that Section 6.1 was intended to protect the Foundation from existential threats from the order, such as disenfranchisement. In other words, a separation of the order from the Foundation such that the Foundation would no longer be the fundraising arm of the order. And as noted, the district court's ruling was based on the order's fundraising efforts. But the illogic of this conclusion is highlighted by its own analysis earlier in its decision that press releases by the order did not violate the 2009 Memorandum of Understanding between the parties because they were isolated statements expressed in the good faith belief that the order faced a budget cut and would soon be forced to close important programs, and that it did not appear that the Foundation suffered significant lasting harm. And the same has to be said of the order's fundraising efforts. They were motivated by the same funding concerns. And as for significant lasting harm, Foundation CEO Ruckman testified at the trial that the type of direct mail solicitation conducted by the order constituted just 1 to 2% of the Foundation's fundraising. Only significant lasting harm suffered by the Foundation was that the Foundation that harm that the Foundation had already inflicted on itself for years before the order's fundraising efforts became an issue.
What about the $50,000 check, Mr. Herrick?
I'm sorry?
The $50,000 check, there's evidence that there was a donor who was going to write a $50,000 check to the Foundation. The order swooped in and said, no, don't make $50,000 donation to the Foundation. Make it to the order instead. It seems like action that is adverse to the Foundation. They seem $50,000 poorer than they would have been.
Well, I think, again, Judge, you have to consider the words other adverse action in the context of the prior language of seeks to disenfranchise. And it's the order's position that the type of harm that we're talking here, the type of action that we're talking here, is action that is an existential threat to the existence of the Foundation, which clearly I mean, when you're talking about a budget of $6.4 million, okay, a $50,000, an alleged $50,000 diversion of a contribution that was supposed to go to the foundation is not an adverse action in that context. It is not an existential threat to the existence of the foundation, such as disenfranchising would be. Okay, so again, whether you include the $50,000 or you exclude the $50,000, the fundraising efforts of the order were de minimis in relation to the fundraising of the fundraising needs of the foundation, and therefore, no legitimate adverse action such as would preclude would allow for the termination of the 2016 settlement agreement.
Okay. Judge Walker, any other?
No.
Judge Rapp?
No.
Okay. Thank you, Mr. Herrick.
Thank you, Your Honor.
Mr. Sturm.
Good morning, Your Honor. May it please the Court, Michael Sturm of Lathrop GPM on behalf of the appellees. Mr. Herrick spent some of his time during argument attacking the foundation, and that's consistent with the leadership of the order treating the foundation as the quote-unquote enemy and planning to destroy the foundation in court. That's at page 1094 of the confidential appendix.
Let's just focus on the legal issues. So, starting with the claim against you, you look at this contract, and 3.3 says the foundation, subject to the priority rules, will fund a reasonable budget submitted by the order. And 5.2 talks about the legal consequences if the foundation does not fund the order. Isn't the most natural reading of fund the order in 5.2 to satisfy the funding obligation set out in 3.3?
Well, no, because the plain language just says does not fund, and it notably uses different language than is used in 3.3.
It uses language that seems like an obvious shorthand.
Well, that's contrary to what...
Fund the order following up on fund the reasonable budget submitted by the order.
It's not that long an agreement, and they use different language. And if you look back at the negotiation history, 5.2 was a highly negotiated position and provision. And the order tried to get in various language into 5.2 that might have helped its position, because originally it said stops properly funding. Later it said does not properly and timely fund. And if they had gotten that in there, those are at pages 266 and 285 of the confidential appendix. If they had gotten some of that language in there, they might have a better position. But the parties settled on does not fund and rejected the broader language, rejected material breach as a provision of a trigger transfer under 5.2. So in view of that negotiation history, I don't think you can reasonably view does not fund as a shorthand, and certainly the district court did not.
And I understand the force of your argument about the extrinsic evidence and the district court's findings. I'm just wondering but that's only helpful to you if we find the contract ambiguous on this point.
But on the plain language, it only says does not fund. It doesn't say does not fund reasonable budget, and that would be presumed. The difference would be presumed to be equal.
Understood, but we find ambiguity only after applying canons of construction. It seems to me the more plausible reading of the contract is that does not fund in 5.2 is a shorthand, but I guess we've talked that out, so go ahead.
Well, and the other thing I would point out, I mean, she read the language in context. The other provisions of 5.2 are dissolution or going out of business. In both of those situations, it would be a permanent and total cessation of funding to the order, not a temporary shortfall. There's the long course of dealings between the parties, which said there was never a guarantee. Essentially, what the order wants here is a guarantee of their reasonable budget. That had never been the practice before. It wasn't the practice after the agreement. It had never been the practice. And in fact, there's also testimony when we get to the extrinsic evidence that both Steve Ruckman, who was the foundation's witness, and Jason Johns, who negotiated from the order, said that during the negotiations, the order never asked for a guarantee, and the foundation wouldn't have given one. So that's at Ruckman's testimony is at 390 to 91 of the Joint Appendix, and Johns is at 712 of the Joint Appendix. So the extrinsic evidence is, all of it points in the same direction with respect to 5.2. And Judge Friedrich made all those findings. I mean, the order hasn't shown that any of them is clearly erroneous, let alone all of them.
Okay.
3.3, I think, is clearly it's a prioritization. It's not a mandate. Essentially, what Mr. Herrick's argument is that 3.3 should create a remedy for any shortfall, but that's not the way it reads. It's just, this is the waterfall of how the raised money is devoted. There's no evidence, going back to the burden argument, there is no evidence that the foundation violated that prioritization. And in fact, there's express testimony from Mr. Ruckman that they complied with the prioritization, they didn't fund the lower priorities, and that's at pages 437 to 38 of the Joint Appendix. Mr. Ruckman also testified that the expenses incurred were reasonable and necessary. Those were at the 492 of the Joint Appendix. And the order also says, what Mr. Herrick said during this argument, that the burden shifting was necessary because the foundation was in sole possession of financial records. Section 2 of the agreement gave the order the right to look at financial records. On top of that, 40,000 pages of documents were produced during discovery, and the only exhibit that the order actually introduced at trial was a financial record, which is at page 1001 of the confidential appendix. So if the order had wanted to try to show some violation of the prioritization at the trial, they could have done it, but they can't retroactively say, oh, it was the foundation's burden to show compliance. It was the order's breach of contract claim. They didn't prove it, as Judge Friedrich found.
Do you have anything on the other claims?
I guess just briefly on the adverse action, Mr. Herrick wanted to compare the situation of the violation of the 2016 agreement with the court's finding that the 2009 MOU was not materially breached. I think the key difference there is the 2009 MOU did not have any provision for termination, whereas the 2016 agreement expressly provided, it singled out, not only is there a termination for breach provision, but on top of that, adverse action is specifically called out as a basis for termination. Again, the language is broad, and on top of that, Mr. Jason Johns, who was the order's own witness, admitted that in addition to disenfranchisement, he said, quote, there's other adverse actions that can take place. That's at page 699 of the Joint Appendix. And Mr. Ruckman also testified at 387 that, in fact, this language was intended as a remedy for the perpetual attacks on the foundation and the tension between the organizations. As Judge Friedrich found.
Can I ask what interpretive significance do you think we should give to the fact that the phrase other adverse action appears right after the reference to disenfranchisement, which would suggest it's not just any old small thing?
Well, it says other adverse action, not similar adverse actions or existential threats was Mr. Herrick's phrase. It uses broad language, and there's no evidence that there's no evidence in the record that the parties meant something other than sort of natural meaning of those words that they chose. And the record demonstrated here that the order diverted funds, it engaged in competitive fundraising using Holdings marks, willfully violated the trademark license agreement, publicly attacked the foundation, and it continued doing all of that even after the default notice was served. So none of that can compare to the issue with respect to the MOU, which was a press release which was subsequently corrected. Even when there was notice of all of these defaults, the the order just kept right on going.
Okay. Judge Rao, any questions? No. Judge Walker?
No.
Thank you, Your Honor.
Does Mr. Herrick have any time?
Mr. Herrick has 30 seconds.
We'll give you 2 minutes.
Thank you, Judge. I don't think it's going to take me that long. The appellee's argument that it had never been the practice of the parties that the failure to fund the approved budget of the order was a default on behalf of the foundation. Well, that was the prior practice. Okay? It's clear that the practice in 2019 did not follow the same pattern. There was no restricted grant issued saying if we can't afford to pay, we don't have to pay. And the reason for that, as was testified at the trial, is that the order would never have agreed to that provision, okay? Because it was clear even before the budget of $6.4 million was approved that the foundation had raised the specter of substantially reducing what had been paid to the order for the prior fiscal years. And in viewing the financial circumstances of the foundation, which were swirling downward at an alarming rate, okay, it would have been foolish for the order to enter into an agreement, that allowed the escape hatch for the foundation that had negotiated in the prior agreements. And
Mr. Herrick, wouldn't it have been equally foolish for the foundation in 2019 to promise to pay the full $6.5 million over the course of 12 months?
Well, it may have been foolish to do that, but that's exactly what they did with knowledge of their spiraling downward finances. Okay, they never, they didn't even present to the order restricted language. It would have been a very simple matter for them to do that. They didn't, and the reason they didn't is because Mr. Ruckman testified at the trial, the order would never have agreed to it. And so it was never agreed to that it was going to be restricted. And given the circumstances in which the money had already been expended by the order, and that was the prior practice, okay, you can't just reduce the payments by 95% and say, oh, too bad, so sad, you don't have a program anymore. You can't have
I just don't see how that doesn't cut both ways. The foundation would have never guaranteed to something it couldn't do, and to your point, the order would have never agreed to something short of a guarantee.
But they did, Judge. They didn't preserve the right as they had in the prior years to not fully fund the order's budget. And they could have done that. They didn't even ask for that restriction because they knew that the order would not agree to it.
Walker, anything else? Judge Rapp?
No.
Thank you, counsel.
Thank you, Your Honor. Appreciate it.
All right, Ann, why don't we release these lawyers, and where are we with Mr. Capel?
Mr. Capel is available. Would you like to proceed with him?
Yes, has the audio been solved?
I believe it has.
Wonderful.
We have Mr. Capel connected. I am going to ask Mr. Fry to join us again.
Okay. Just give me a minute to reshuffle my papers, and I'll be right back.
Thank you, Judge. Mr. Capel, I have just sent you a request to please unmute your phone. Please unmute your phone. Your phone is still muted. You can press *6 to unmute your phone. Mr. Capel, can you please say something so we can test if we can hear you?
Hello, can you hear me now?
I can hear you.
Here he is. Yes, we do.
Yeah. Well,
All right. Sorry for the glitch. We are doing the best we can in strange times. So, Mr. Capel, please proceed when you're ready.
thank you, Your Honor. And as I was trying to say at the beginning, it was nice to see you as well. May it please the court, I'm John Capel from the Department of Justice, representing the Appellee's Secretary Azar.
You're going to have to speak up. We can hear you, but it's faint. So please stay close to the phone and speak up.
Okay. The plaintiff does not dispute that it's received all of the contract support costs that it was entitled to receive under the funding agreement and the compact. Instead, now the plaintiff is seeking additional costs, contract support costs, essentially that are abstract costs. The plaintiff is not seeking any specific additional costs. Instead, it is making an abstract legal argument that is entitled to further contract support costs, even though it has not shown any additional costs. And when one looks at the way contract support costs are computed, which is determined under not by the statute itself, but by the Indian Health Manual and the agreement of the parties, the plaintiff must has to the calculation for contract support costs is based on the secretarial amount, and the direct costs, and then a percentage of that figure to compute indirect contract costs. Now, again, the plaintiff has not even attempted to show any additional direct costs. Instead, the plaintiff is saying that it's entitled to 5.065% of the figure, the additional figure that comes from the program income. But that is not the way the contract support costs are computed under the Indian Health Manual, and the statute does not override that in any respect. Statute simply does not.
Can I ask Mr. Capel on the statute? One of the arguments is a very complicated scheme, but if I'm tracking it correctly, one of the arguments the tribe makes is that these costs fall within the secretarial amount. And one of the reasons they say that is that 5388C includes any funds that are specifically or functionally related to the provision of services and benefits to the Indian tribe. And that seems functionally related to the provision of benefits seems like a broad formulation.
Well, Your Honor, again, we've addressed 5388C in our brief, but that is not the way the statute should properly be read as a whole. And the statute draws a clear distinction between program funding, or the secretarial amount, and program income. And that comes from first of all from 5325A A1 through 3, which defines the secretarial amount and contract support costs, and 5325M and 5388J, which discuss program income. And the 5325A1 itself defines the secretarial amounts as the amount of funds provided under the terms of the self-determination contracts, and it shall not be less than the appropriate secretary would have otherwise provided for the operation of the programs. So, in other words, that is the secretarial amount. It is a substantive amount, and it has nothing to do with program income. Program income deals that is defined in 5325M, which says that program income earned by the tribe in the course of carrying out the contract shall be used by the tribe to further the general purposes of the contract, and shall not be used and shall not be a basis for reducing the amount of funds that are otherwise obligated. In other words, the secretarial amount. And what this does, 5388J is comparable to that. It sort of does the same thing, but it uses slightly different language. It says that the amount is the program income is supplemental to the other program funding. But
I think I think you're right to the extent we're looking in the four corners of 5325. I'm just wondering why 5388C might not expand 5325, because it says amounts specified under 5325A1, which is the secretarial amount, and amounts for support costs, which are the CSCs, and then it has this including language, which seems to broaden the scope of what the secretary is obligated to fund.
Well, again, in our view, that does not override the definition and of program funding, or the secretarial amount, and the distinction between that and program income. And again, it's also supported in 5326, which was previously discussed, which does indeed apply to compacts by its very terms. And it says that the compact support costs may be extended only for costs directly attributable to contracts and compacts, which again is not that the program income is not directly attributable to it. Now, again, we don't believe that the language in 5388C somehow overrides the provisions, all of these other provisions of the ISTA, and that. Okay. So,
Mr. Can I ask you a question, Mr. Cabell?
Yes.
I was wondering, under the statute, would it be possible for the tribe to contract with IHS to receive CSC for the program funds? Or would that be barred by the statute's limits on duplication or other restrictions that are in 5325? I mean, is it possible for them to contract for that as part of CSC?
No, Your Honor. We believe that they're getting all the CSC that they're entitled to under the statute and the contract by virtue of the existing arrangement. And of course, they do get their program billing expenses. That is something that they have undertaken, right, to the extent that they're seeking third-party costs, and they have assumed that responsibility, and they're getting reimbursed for that as part of the secretarial amounts. But
would the statute bar contracting for reimbursement of those fees? Would it prohibit? I understand you're saying it's not required by the statute, but would they be prohibited from contracting for that reimbursement?
Well, yes, I believe that in that situation, the Indian Health Service would take the position that those are not proper costs, and therefore it would decline the contract. Of course, here the plaintiff has raised this kind of at the back end of the process. It's raised a contract a claim, a Contract Disputes Act claim for breach of contract for additional damages, which it is claiming are in the amount of this, as I said, abstract, unspecified contract support costs, and that is just not the way the statute works, and that's really the essence of the government's position. Let me see if there's anything else that I wanted to cover.
Let me jump in if I can, as long as I'm not interrupting. Judge Rao, I'm not interrupting your line.
Yes.
Mr. Capel, let me ask two questions, and this one of them, unfortunately for me at least, has a little bit of math. So I'm gonna start with the other one. Doctors have compliance costs when they bill Medicaid.
Right.
Back in the old days when IHS was running the services on tribal lands, IHS used to bill Medicaid. Did IHS have compliance costs back then when it billed Medicaid?
I'm not sure. I don't believe so. I'm not entirely sure. When you're referring to compliance costs, what exactly does that entail?
Well, as I understand it, the federal government sometimes requires audits. Sometimes they require more complex accounting than a contractor might otherwise do. I mean, in the case of the tribal health services right now that are contracting with IHS, we're told that their compliance costs are something like 30% of the money they actually receive from the contract. And I don't care whether it's 30% is right or 25 or 15. But there seems to be a recognition that when you're getting money from the federal government imposes some requirements that cost you money, some compliance requirements. And I'm sure that every doctor in America who bills Medicaid has to satisfy some compliance requirements. And I'm sure that satisfying those compliance requirements costs them some time and money. And so I would imagine that IHS had compliance requirements back when it was running the services on the ground and when it was billing Medicaid and when it was receiving money from Medicaid. I don't really know how they couldn't have had some compliance costs that went with billing Medicaid. So my first question was, do you agree and I'll ask you again. And if you don't know, you don't know. It's not that you.
Well, Your Honor, in our view, those whatever compliance costs, whatever overhead and general costs they had would be factored in under Medicare and Medicaid, and that's the program manual, but the Medicare provider reimbursement manual and the state Medicaid reimbursement manual.
So I think let me interrupt.
Part of that money is providing for overhead and whatever costs are incurred that way.
Okay, Mr. Capel, please let me ask. I think that's right. That's what some of your briefing says about the fees that Medicaid and Medicare pay. They're based not just on the direct health services that are being provided, but they're also based on compliance costs. So here's my again, at the risk of showing my lack of math skills, here's my math question. Back when IHS was running the services on tribal lands, let's say there was 1 year where, and I'm going to use really small, really simple numbers for my own sake here. Let's say there was 1 year where IHS billed Medicaid for $2,000, okay? And Medicaid then writes them a check for $2,000. And there's an obligation on IHS to spend that money on that tribe. Now, here's my question. Let's say that complying with Medicaid costs about 30% of what you get from Medicaid. My guess is that IHS would have then spent $1,400 of that $2,000 on providing direct health services. And it would have spent $600 of that $2,000 on the compliance costs that come with having to deal with Medicaid and Medicare, which, to be frank, is not something I would wish on my worst enemy. If that's the case, if that's how it worked, then I think that the tribe is wrong here. I think they're getting, assuming all else is the same and constant, they're getting $2,000 the next year from Medicaid, and they should spend $1,400 of that on direct health services, and they should spend $600 of that on compliance costs. And to the extent they chose to spend all $2,000 of the $2,000 on direct health services, and they don't have the money, the extra $600 left to spend on the compliance costs, well, they didn't do it the way they were supposed to do it. They spent too much. So I think you're right if that's how it all worked. But here's my question for you. Back in the old days when IHS was running these health services themselves, maybe it was the case that when IHS billed Medicaid for $2,000, IHS turned around and spent all $2,000 of that on direct health services. And if that's the way it used to be, then this new system does seem like it's worse off for the tribe. There's $600 less dollars being spent on direct health services. And I suppose if this is the thing that had happened, if back in the old days Medicaid had spent all $2,000 on direct health services, I mean, that extra $600 compliance costs had to come from somewhere. It's possible IHS just found that money somewhere else, out of its treasury, out of its, some other account, and spent it. And if that's what was going on, my concern is that the tribe is worse off when it has made a choice to provide health services itself rather than letting IHS run the show. So I guess that was a really long question, but there's really one small part of it that I wonder if you could help me with. Back in the old days, when IHS was providing health services itself and it billed Medicaid for $2,000, did it spend all of that on direct health services, or did it spend part of that on direct health services and the rest of it on compliance costs?
Well, Your Honor, I'm not sure. I can't answer that question sort of directly because I'm not exactly sure how that worked. But I do know that under the statute now, when IHS is running the program, it is obligated to use all of the funds that it gets from Medicare and Medicaid for the program for program costs. But perhaps the main point is that if the tribe believes that it actually has other costs, that it has incurred specific costs as a result of receiving program income, certainly it is able to make a claim like that and make a showing with the IHS. But it has not done anything like that here. What it's done is arguing that basically it is a purely theoretical matter based on its, in our view, incorrect understanding of the statute, that they were entitled to additional CSC computed, in accordance with a formula of their own creation that's based on the amount of program income they've received. It's not tied to any specific costs, and that is what's that's the crux of the problem with their position, and this is not the way the statute works, and it's clear that in our view and in the view of three of the four district courts that have addressed this issue, it is clear on the face of the statute that that's not the way it works, and so obviously
can you just clear, Mr. Capel? Mr. Capel,
the Indian canon doesn't come into play.
Mr. Capel, can you just clear up? I heard you to say in that answer that if the tribe wanted to, it could at least try to negotiate for a claim to get the compliance costs that come with billing Medicaid. They didn't do it here, you say, but they could at least try to do that negotiation if they could prove what they need to prove. But I thought you had told Judge Rao that they're not allowed to do that. Did I misunderstand one of those two answers?
I'm not. What I'm saying that they're not allowed to do is give them a percentage of the program income based without any showing of actual costs, without any satisfaction of the criteria that the Indian Health Manual establishes for direct and indirect costs, contract support costs. So that is really, we're not saying that they can't make a showing with respect to claimed additional contract support cost expenses, but they have to be concrete. They have to be specific, and they can't be based on this abstract formulation or legal construct that the tribe has made here.
Judge Rao, any?
No.
Judge Walker? Okay, thank you, Mr. Capel.
Thank you, Your Honor.
Mr. Fry, we'll give you a few minutes.
Thank you very much. I can answer Judge Walker's question. Back in the old days, IHS spent 100% of its program income on facilities. It was required to under the previous incarnation of the law. Now, under 1641C, IHS is required to spend 100% of its program income on either facilities or expanded health care, not overhead. So your hypothetical, Judge Walker, I think, is correct. We are getting less for our compacting efforts than the government would have received under the old regime. And where it got that money is from a separate bucket, the direct operations bucket, which is under, I think it's A2B. That's a separate bucket from which the IHS gains revenues and which we're entitled to. Now, I agree with Judge Katsas as well. 5388C, the including phrase.
Sorry, before you get there, just walk me through that once more. You said that IHS would have to spend all of the program income on providing health care as opposed to overhead?
Yes.
So how would they, from what source would they get funding for the overhead and the compliance costs and things like that?
It would come from other funds in the department, and specifically the direct operations budget item that funds these things. And that's, I think, the contribution of the amici on pages 21 and 22 of their brief. So if that's sufficient, Judge.
Yeah. Okay.
So the including phrase in section 5388C does indeed expand the tribe's entitlement, and the agency that agrees with us on that is HHS. 42 CFR section 137.79 construes that including language to be in addition. So yes, we agree with the thought of Judge Katsas in that respect. And
Mr. Fry, the including phrase refers to services and benefits, which strike me as a little bit different than earnings. Can you help me with that concern?
I will certainly try, Your Honor. Well, C begins with the Secretary shall provide funds, including contract support costs, including any funds that are specifically or functionally related to the provision of services. So the funds are related to the provision of the services, and the provision of the services are the provision of medical services to people covered by Medicare, Medicaid, in my reading of that.
Okay.
To Judge Rao's question, the Indian Health Service will not even entertain negotiations on CSC being part of the A1 amount. It's off the table. And to the main point, I think, of my colleague, we agreed to an indirect cost rate of 31.91%. And Judge Rao, that's actually quite a bit less than even the percentage for HHS. There's a study that was done and reflected in a hearing in 1999, I believe, serial number 106-52. And the concern that was raised was all the tribes are getting out of control with their indirect cost rates. It turns out they're roughly half of what the indirect cost rates are for federal agencies, state agencies, universities, and others. So, and that's on page 26 of that particular study. The 31.91% isn't just a lawyer's abstraction. It's an agreed upon figure that the Office of Management and Budget recognizes is a necessary expedient. You can't go and nickel and dime different operations to find, absolute specificity and precision to overhead costs. We don't, and IHS doesn't have separate staff that provide services to people covered by Medicare and Medicaid. It's all within our organization, and we agreed that the 31.91% was the appropriate rate, and that extends throughout all of our program and all of our staff. And I note that this concern.
You're over time, Mr. Fry. Judge Rao, any questions? Judge Walker?
No.
Okay, thank you, counsel.
Thank you.
Submitted.
This honorable court is now adjourned until Friday, October 2nd at 9:30 a.m.
Goodbye.